Morning.
For
Yes.
admission, item number 1.
Your Lordship, this contempt case has been contested in the sense the respondent number 1 has filed affidavit, whereas respondent number 2 and 3 have not filed as yet.
Yes, who's appearing for 2 and 3?
For 3, my lord.
Are you filing any?
Yes, my lord. My lord, what I have seen from the affidavit filed by respondent number 1, that they have filed a review petition before Supreme Court of the order,
Yes.
dismissal order of SLP. So we might have to wait, my lord, because that if a review petition is there,
Is there any stay?
yes, my lord.
There is a stay?
Your Lordship, at page 8,
Page 8 of the?
page 8 of the affidavit of the respondent number 1, statement has been made to the fact that
Yes.
on 4/1/2024, SLP diary number so and so was listed for final hearing before Honorable Supreme Court, and the Honorable Apex Court disposed it of by its order dated 4/1/2024. The operative portion of the court order dated 4/1/2024 as under. We are not inclined to interfere with the impugned judgment and order passed by the High Court.
There is no stay in the review petition.
There is no stay.
Then-
It is
then
not
why-
known. It is not known as to
Pendency-
whether they have filed it or not also. Because
Be
they
that
have not,
as it may, if you want to file your response, you file it. Otherwise, we will hear the contempt petition. Because the order of this court is not been interfered or stayed. Then, merely because of pendency of some case will not mean that you will not comply with the direction of this court.
Yes, sir.
Correct?
that's true.
So either you file your response
My lord,
or we will take up this contempt petition.
my lord, I have filed my response.
Some pendency of some review petition is no ground for not compliance.
Yes, sir.
And the number of the review petition is also not given. It is simply
Be
stated
that what it may
is-
be, it is
being
absolutely
filed.
clear that the apex court has not interfered with the decision of this court.
That's true.
Correct?
Yes.
To that, a review has been filed. What has happened is not known to this court. That doesn't mean that the orders of the court will not be followed. Of course, if there is a stay order, that's a different situation.
That's
But that nothing has been brought on record. Mere pendency cannot be a ground for non-compliance of the court's order, isn't it?
true.
So yes, how much time?
3 weeks, my lord. My lord has fixed yesterday 2 matters on 22nd of October.
Is it connected to that?
No,
It's not connected, but it's connected to him.
Convenience of my lord.
Now you can always appear through video conferencing mode also. But anyway, you need 2 weeks time,
3 weeks. sir.
3 weeks.
Your
This
Lordship,
matter is going on for a long time.
for a long time, yes.
You have been,
I've been
you
waiting.
are R3.
I am R.K. Agarwal.
You were impeded on 15th of February 24.
My lord, I am impeded at a later stage.
Yes, I have the order sheet.
Yes, ma'am.
In fact, this court's order, let notice be issued the newly impeded R3
Yes, ma'am.
on 15/2. Then on 15/3, Mr. P. Goswami. So you are Mr. P.
Yes,
Goswami,
ma'am.
correct?
P. Goswami.
You appeared on in the month of March,
Yes.
and now we are in the month of September. In a
My lord,
contempt petition, why so much time for filing your response? It has to be taken a little seriously.
My lord,
What is the order?
The order that has been violated
Which page?
at page, starts from page 40,
1-4?
40.
Yes. 9, 8, 11, 18.
Starting from 7A, yes, 8/11/2018, yes. It's
Seven,
it's a
yes.
claim for payment of solatium and interest, which has been adjudicated by this honorable court, and the matter was taken to the Supreme Court after that, 2018.
So direction was to the district collector, that is R3.
Yes.
to make an assessment of the solatium and interest entitled to each of the petitioners for acquisition of their land in terms of the award to so and so. This is not done.
It has not been done. Assessment was made and it has been communicated to the parties. also. But
Then,
in spite of that, the matter has been delayed so much.
see, this matter is of 2018 did the elections.
Yes, my lord, in MHA is the Ministry of Home Affairs is the paying authority. From January until date, I have given 6 letters to them. These are the letters. This can be for record.
Yes. Who is appearing for the MHA? What is your stand?
My senior CGC is on lock.
No, your senior may be on legs, but don't you have the brief? You are a government advocate? You are junior to Ms. Sangpui. Sangpui is appearing. So there should be, if you are junior, then you must have the brief here when the matter are listed. Anyway, you see, if it goes on like this, then this court will take some serious actions. If required, we'll ask the officers to be present in the virtual mode and explain what is happening. It cannot go on like this.
Yes.
The order of the court is of 2018 and we're in 2024 now. SLP also dismissed. It cannot go on like this. I'm making this very clear to all the councils. Please communicate it to the hearing officers.
Lots of
My lord,
clear instruction may be given.
One minute intelligence, my lord.
Yes, Mr.
My,
Goswami.
Respondent number 3, actually he is not the, by virtue of he being the chairman, CMD of the main company, he has become the chairman of the subsidiary company. This
See,
is-
as far as R3 is concerned, he's already made an assessment, correct?
Yes.
So assessment is done.
Yes, my lord.
Now after assessment,
R3 is not the one who made the assessment. It is the deputy commissioner.
okay. But
Deputy commissioner
assessment
had
is done.
communicated,
Now
yes.
after assessment, there has to be determination as regards the entitlement of the petitioners, correct?
Yes.
That
yes.
determination is not done.
It has been done.
It has been
It
also
has
done.
been done.
Then what is the stage? Dispersal.
Yes. Compliance of the order.
That means depositing.
Yes.
Depositing the award amount.
Yes, my lord.
That is what is the stage at
Yes,
now. Have I understood correctly?
Yes, your lordship.
Assessment, determination, all done.
Yes.
Now it is at the stage of depositing the award amount. Right?
Yes.
Okay.
Your lordship, by a letter dated 15/7/2024, which my learned colleague has
I have given right now, my lord.
submitted
Yes.
to your lordship.
Last,
Last para of
15-2.
15/2. That letter,
Yes.
15/7.
15/7/2024. Yes.
Yes.
In which it is written, under the aforesaid circumstances, approval is sought for payment of interest, solicium, and other statutory liabilities amounting to so and so, till 18/3/2024, and to further approve for payments if, in case, further demand is made by landowners for payment of interest, solicium, and other statutory liabilities till the date of payment. Aforesaid amount be released by MHA to NPCC for payment at the earliest.
All right.
So, my lord, I am writing almost daily. 6 letters I have already sent my department. And to be very honest, my lord, respondent number 3 would not be liable for contempt.
Who is the Director, Department of Border Management, Ministry of Home Affairs? Is he a party here?
He is not directly a party, but he is under the respondent number 3. CMD, respondent number 3 is CMD of National Project Construction Corporation Limited. Whereas,
No, I think because
My lord, he is from Ministry of Home
Correct.
Affairs.
Ministry of Home Affairs,
Yes,
Mr.
my lord.
Lalram Zwaba.
Oh, lots of.
So who is he here? Party respondent? Is he a party respondent? Is the
This
Department
director
of
is not a
Home
party.
before this court?
Yes, my lord.
Who- which part?
Secretary is the,
Respondent number?
Respondent number 1. That's the
he has
main
filed the
respondent.
affidavit.
R1 is the Secretary,
Yes, ma'am.
Ministry of Home Affairs.
Yes, my lord.
Yes, Mashwar.
My lord, this may be kept on record, this.
Heard Mr. C. Lalram Zwaba, learned senior counsel, assisted by Mr. So-and-so, learned counsel for the petitioner. Stop. Also heard Mr. P. Goswami, learned counsel for respondent number 3, and MS so-and-so, learned counsel appearing for respondent number 1. What about the respondent 2?
Respondent number 2 is the earlier CMD,
He has retired, my lord.
who has retired.
No one is representing him.
No one is present.
Borvia is representing.
He's
Mr.
not there.
But he's not there.
Okay, so 3 respondents. Okay. Did you say? Mr. P. Goswami, learned counsel, appearing on behalf of respondent number 3, submits that by various correspondences dated 13/1/2024, 15/2/2024, 2/3/2024, 6/2024, and 15/7/2024 had requested the Department of Border Management, Ministry of Home Affairs, Government of India for approval for payment of interest, solitium, and other statutory liabilities amounting to rupees 858,11,747 till 18/3/2024, and to further approve for payments if in case further demand is made by the landowners for payment of interest, solitium, and other statutory liabilities in terms of this court's order dated 8/11/2018. Stop. It appears that the Minister of Home Affairs, within bracket respondent number 1, is sitting silent over the matter as regards the payment of the awarded amount. Before this court considers taking strict action against the erring officers, a last chance is given to the respondents to comply this court's order dated 18/11/2018 in full spirit. Stop. List this matter accordingly. Give a date after 4 weeks. Last chance is given, so yes. Tell your officer, whatever is to be done should be done.
14th of October.
14th October. All right?
My lord, if it is on 22nd
22nd?
of October.
Okay, 22nd October. And copies of the correspondences dated, handed over by Mr. P. Goswami is kept on record and marked as X.
To the respondent also.
Yes, give a copy to that. And if required, you file a short affidavit.
Yes, my lord.
Item number 2.
Mark X.
My-
And see, copies is given to the petitioner also. Copies of which is also given.
May it please your lordship,
Yes.
this contempt petition has been filed due to the non-compliance of this honorable court order dated 1/6/2022, page 30, my lord.
Notices have been issued.
Everything has been completed, my lord. At this stage, the first order passed by this honorable court, that is the order dated 17/3/2022 was complied with by the respondents. However, vide order dated 1/6/2022, passing IA 74 of 2022, this Honorable Court directed that the 15% cess deducted from the compensation amount of the petitioners was to be paid within 6 months, failing which interest at the rate of 6% will be imposed on the state government. At this stage, we are at the stage of interest. And my lord, I have given one letter that is 5/2/2024 to the bench clerk. Herein, the respondent number 4 had sought for sanction of rupees 13,12,260. That is the interest due to be paid to the petitioners.
Where is the order of this court which is not complied?
Page
according to
30,
you?
my lord, page 30 of
Page?
the 30.
AC is working. I'm feeling little warm. Yes,
The last paragraph, my lord.
yes.
If I may read with your lordship's permission.
Directed, yes.
Yes, having heard both the parties, this court finds it fit to allow the IA as paid for and the state government are directed to release the deducted 15% cess to the petitioners in WPC number 31 of 2022 within a period of 6 months from today, failing which an interest of 6% will be imposed on the amount due upon the state government from the date of the judgment and order in WPC number 31 of 2022. Thereafter, the respondents have kept on hold the 15% and they have not made payment.
What is the stand?
Pardon, my lord?
What is the stand of the respondent? Why is this order not complied?
The
Where are
stand,
the respondents?
respondents are not present today, my lord.
Ms. Mary is appearing.
Miss Mary is appearing.
She's
For
on
the
a maternity leave, I think.
Yes, my lord.
I'll have it next week.
Yes, my lord, we can have it next week.
Heard Mr. Zoram Sana,
Yes, my
Senate
lord.
counsel for the petitioner, stop. None appears for the respondent when the matter is called. It is submitted at the bar that Ms. Mary Lalrotkimi is on maternity, representing the respondent numbers 1 and 2.
And 4 also. my lord.
1 and 4 is on maternity leave. List the matter after 2 weeks.
1 week. Ah, yes, my lord.
When is any idea when is Ms. Mary joining? Mr. Samuel? Because in some matters I have seen she has been joining through video conferencing mode.
Yes, my lord.
So
By the end of this month, my lord.
Item number 3.
you take this back.
Yes, my lord.
Service completed.
Yes, my lord, but the respondent 1 and 2, till now, they have not appeared before this court.
This is second appeal.
Yes, my lord.
What is the substantial question of law involved?
It's at page 25, my lord.
Page
25.
Yes, please read.
Whether the first appellate court erred in law in remanding the case for de novo trial as the suit in question had not been disposed of on a preliminary point by the trial court, and considering that the decree has also not been reversed in appeal. B, whether the first appellate court has sufficient material or evidence on record to determine the case on merit. C, whether the issues framed by the learned trial court is enough to determine.
Where is the order
appeal.
of the first appellate court?
It's in the first, my lord, Roman 1. You got it, my lord?
1 second. Yes. Where is the discussion on the remand?
Said, page 23, Roman,
Roman 23.
my lord.
Paragraph
11.
read from para 10, please.
The learned trial court is to kindly take note of the history of the case, which needs to be considered in order to understand the issues between the parties and to arrive at a judicious conclusion. It is worth pointed out in brief as it is clearly revealed by the written statement and counterclaim in the original
Dina.
suit. Arilaw mo. Original suit and deposition of the defendants and cross-examination of plaintiff witnesses. The plaintiff number 1, Pupazo Nalate, was the brother of Pulangye Nalate, and they were both unmarried and lived together. Pulangye was issued the periodic pata number so-and-so originally for a period of 5 years, that is still 31st 12/1983, and beyond which it was to be renewed within 6 months of its expiry. However, Pulangye passed away in 15/4/1980, and his brother Pupazo Nalate continued to live in the suit land and allegedly took in his legal representative. After Pulangye died, Pupazona took no action regarding renewal of the said periodic pata. In the year 2001, cadastral survey was conducted by Revenue Department in No.2 area, and notice was given to all residents to be present during survey with their pass. Pupazona and appellant number 2 were also present, and their land was surveyed. Pupazona claimed the entire area covered by Pipata number so-and-so except the land over which the house of appellant number 2 was constructed, as he allegedly had given him the said portion. However, as he had no supporting documents, only the land in and around his residential building was surveyed, and LSC number so-and-so was issued to the appellant number 1. Pupazona, covering an area of 0.52 bigas, and LSC number so-and-so was issued to appellant number 2. Vanland mga Izwala, covering an area of 0.17 bigas. Both appellants had no objection to each other's land. Time went by. Pupazona passed away on 9/5/2011. After his death, the respondent number 1 filed heirship certificate number 69 of 2011, and it was issued accordingly. However, legal representative of appellant number 1 filed review of the same, and it was considered and allowed, and the heirship issued to the respondent number 1 was cancelled. Then the legal representative of the appellant number 1, namely Vanlal Thanpuya, filed probate application number 4 of 2011 for probate of will left behind by Pupazona, but the same was dismissed by JMFC with a direction to approach appropriate court. Meanwhile, the respondent number 1 filed the original suit, civil suit number so-and-so, against the appellants and annexed a renewed copy of Pipata number so-and-so, which was shown as renewed on 17/6/2002, and as per Muninpeng na lekha signed on 27/6/2002 by Pulangye and respondent Valal Moya in witness of Pupazona and Pukolram Thanga. The renewed Pipata was transferred in the name of respondent number 1, Vanlan Moya, on 1/7/2002.
The heirship certificate proceedings
My lord.
are under what provision? Is it akin to the succession proceedings?
My lord, sorry.
Succession proceedings under the Indian Succession Act?
Yeah, my
Is
lord.
it similar or?
Similar. I mean, the heirship certificate is filed for succession of the land.
No, that I've understood. So, what is the, anybody present here can also address the court on this if it is clear. Heirship certificate proceedings are under what law? Is there any law?
Without marriage, my lord.
The inheritance?
Yes, yes, my lord.
Huh?
Without marriage, divorce and inheritance of Property Act 2014.
And generally when the applications are sought for,
My lord.
an advertisement is given,
Yes,
right?
my lord.
And after the advertisement, if objection comes, what happens?
Trial.
Trial takes place.
Yes, my lord.
That is under the CPC.
Yes.
Correct. Is it correct, Mrs. Samuel? That is the procedure? Yes. All right, then 11. You wanted to draw my attention to para 11? Yes, with the above reasons.
With the above reasons and finding the instant appeal is allowed to the extent that the impugned judgment and order 18-10-2021 along with decree dated 18-10-2021 passed by the learned senior civil judge for Azol District Azol in civil suit so-and-so is hereby set aside and quashed due to non-consideration of counterclaim referred by the appellants. The suit is sent back for trial de novo from the stage of settlement of issues in relation to the counterclaim made by the appellants, that is, defendant 1 and 2. My lord, the counterclaim in the learned senior civil judge from the order, we can see from the order, it is at page 42.
All right. Your questions, according
lord.
to you, why are they substantial? It has to be a substantial question of law, meaning thereby there has to be some material rights of the parties involved,
My lord,
right? What is the right involved? Why is this question of substance according to you?
my lord, from A, the de novo trial, it was sent back for de novo trial. And when the trial court disposed civil suit, the counterclaim from the defendant, it was not considered by the civil
That
Civil
is that
judge.
a substantial question?
I mean,
What is a substantial question? Are you carrying the apex court any decision? Hajari, I think, where it is clearly laid down. Are you carrying any of these authorities?
not today, my lord.
All right, I'll have it on Monday then.
My lord,
Because you see, for admitting and framing the formulating the substantial question, presence of respondent is not required.
my lord,
Generally, after admitting and formulating, notices also can be sent to the respondents.
my lord,
Because they have a right at the hearing to show that the substantial question framed does not involve any question of substance. That is always there. So you come prepared on Monday,
my lord,
okay?
my lord,
If the question has any substance, I shall formulate and admit it.
my lord,
But you have to satisfy me
my lord.
that substantial questions are involved. So first find out those 1 or 2 decisions of the Supreme Court. I think Santosh Hajari.
Yeah, my lord.
All right.
Oblige.
List on Monday.
Item 4.
Yes.
Mr. Lordship,
First day. Which is the order?
sorry? my
Which is the order which according to you has not been complied?
lord. Yes, my lord, it's order dated 3/11/2023 in WPC
Page
111, 111. That operative option portion would be
1.
115.
One second.
Second para,
115.
115.
Yes.
This court, considering the limited prayer made by the learned counsel for the petitioners, finds it fit to dispose the instant writ petition at the motion stage itself by directing the respondents to respond to the representation submitted by the petitioners dated 29/8/2023.
This is not done.
Not done yet, my lord. Notice was issued to this particular respondent, that is State Project Director, Samagra 6 Mizoram. However, during the
Within 3 months, the representations were directed to be considered.
yes, my lord.
This is not done.
This is not done.
Okay, I'll issue notice.
Notice was issued earlier to
Where are the
However-
respondents?
respondent number 6, and then the new incumbent due to posting of transfer, new incumbent, that is 7, respondent number 7.
Was
It
impleaded.
is impleaded again, and notice was issued. ID card has not yet returned.
Also,
So,
all
if
right.
your lord-
Await surface in respect of the newly impleaded respondent number 7. List after 2 weeks on a date to be fixed by the registry.
Item 5.
Counter filed.
Yes, Lord. May I seek another 2 weeks' time for filing counter affidavit, since we did not receive any instruction from the concerned authority?
My lord,
You are for the CGC.
Yes, my lord.
Yes, Mr. Samuel, are you there?
On behalf of the respondent number 2 and 3, my lord, we have already filed.
You all have filed.
Yes, my lord.
Respondent number
2 and 3.
2 and 3. Have you filed your response to 2 and 3?
no, my lord.
You want to file?
No, my lord.
You'll not file.
Yes. My lord, if I make one small submission, my lords. This is a limited prayer to conduct spot verification, and if my land is indeed within the ROW, then let appropriate compensation be made. That is only my prayer. And my lord, till date, even though the notice has been served to respondent number 4, they are yet not represented. Lordship, if
Who is not represented?
respondent
Who
number
is the
4,
main respondents here?
Your lordship, the main respondent would be the Kala, competent authority for land acquisition.
They are before this court.
Not yet, no one has appeared till date.
Notices otherwise have been served.
yes, my lord.
Respondent number 4.
R4.
Yes. My prayer is for the respondent number 4 to conduct spot verification upon my
Yes, but there has to be someone for R4.
Yes, my lord.
I can pass that order,
Yes.
dispose of this writ petition. But if there is no one representing R4, it will have difficulties for you to get the order implemented. Isn't it?
Yes.
And that order would be also something like a consent order. So if R4 was here, but where is the note showing that notice is complete in respect of R4? I'm only finding 2, 3, 1. 4 is not mentioned only. Oh, here it is. None appears for R4. It is seen that notice sent to the respondent number 4 was tracked through internet, and upon doing so, it is seen that the notice has been delivered. But what is to be done? They are still not there.
If they still fail to make an appearance on the next date fixed, my lord, let us proceed. let us proceed without respondent number 4. Proceed.
What do you both say to the prayer for disposing this case with a direction for making a verification, and in case the result of the verification show that the land of the petitioner has been affected, then in accordance with law, compensation.
Yes, your lordship. That is this time, my lord. But if we look at the affidavit in opposition submitted on behalf of NHIDCL at page 4, the petitioner in this present case, my lord, is claiming that around 1,500 meters is cutting through his landed property.
Yes.
Now, my lord, upon verification, it is found that the plot of the petitioner is 1,500 meters away from the alignment.
So it's outside the ROW.
Yes. And now with regards to NHIDCL, they have signed an agreement with
Which is this paragraph, Mr. Samuel, you're relying
Page
on?
4, my lord.
Paragraph 4.
Paragraph number
Page 4.
paragraph number 4, page 4, my lord.
Okay.
On top, my lord.
That the plot of the petitioner is 1500 meter away.
Yes, yes.
Then you have no
No, that is why,
case.
NHI,
that is why we claim for spot verification, my lord.
They have cleared.
I have annexed
This
the,
is, you are not filing a rejoinder also to this.
Lordship, I have filed my, that the maid's photo also in my petition.
Maybe, but this is the affidavit of NHIDCL
yes, your lord.
where they have clearly said and it says it has been verified through the authorities engineer and EPC contractor. They've already done a verification.
It's
Why should this court not accept this affidavit and the averments which are made on the basis of an on oath?
Lordship, if I take it, Lordship, to page 32 of my petition, Annexure 4.
Page
32, Annexure 4. That is the still camera photo, my lord. That those damaged land were all within my land, my lord.
how do we know?
That is why I prayed for spot verification, my lord.
Can't be like this. Anyway, you want to file something? See, Mr. Counsel, unless you contest this averments, we will take them to be admitted. You have a right to reply.
Yes, my lord.
That is why I'm
Indeed,
asking you.
If I may be given time to submit my reply.
I will give you time, but I asked you in the beginning, you said you don't want to file a rejoinder and you simply want this court to dispose of this case with a direction for verification. But when it is clearly said by NHIDCL that your land is outside, unless we see something to doubt that, why should we unnecessarily direct for a verification? Isn't it?
Yes.
So you have to come up with something so as to get that order if you want. Otherwise, we will close this writ petition because the government affidavit is clear.
I'll file a short reply, my lord.
You file a long reply, that is your prerogative. It is your right which you have to assert. All right. As prayed for by Mr.
There'll be a
So-and-so,
no,
learned counsel for the petitioner, this matter is adjourned for 2 weeks to enable the petitioner to file rejoinder to the affidavit, to the counter affidavit filed by the respondent number 1, 2 and 3. Stop. In the meantime, respondent number 1 is directed to file their response as well as prayed for by MS
Baby, Laldin
so and so. Okay. And on top you record their presence. So and so for the petitioner, so and so for Mr. Samuel, so and so for respondent 2 and 3, and MS so and so for respondent number 1.
Much obliged.
Obliged.
Obliged, my lord.
Item number 6.
Lordship, may I seek another 3 weeks' time for filing affidavit in opposition for respondent number 1 to 3?
In item 6.
Yes, my lord.
All right.
My lord, even though notice has been served to the respondent number 7, they were not represented till that.
I cannot force someone to appear if they're not represented. They've been served.
Yes.
It's a writ petition. And you are for?
Respondent number 1 to 3.
And Mr.
State
Samuel?
respondent is respondent 4 to 6. ma'am.
4 to 6.
Heard Mr. So-and-so, learned counsel for the petitioner, MS so-and-so for respondent number
1 to 3.
1, 2, 3, and Mr. Samuel so-and-so for respondent number
4 to 6.
4 to 6. None represents R7 despite notice being served. As prayed for by Mr. Samuel, you will be also filing something?
Yes, your lordship.
As prayed for by the respondents, list this matter after
3 weeks.
3 weeks to enable the respondents to file their respective return in the matter. List after 3 weeks on a date to be fixed by the registry.
Highly obliged.
For order. Item number 7.
Yes, service on 3 and 4 is done.
No, my lord.
It's still awaiting.
Yes, my lord, as per the office note.
Yes,
dated
5-9.
Yes.
You are for?
Lordship, I'm for the respondent number 1 and 2.
All right. Await service in respect of respondent number 3 and 4. List after 4 weeks
Okay, my lord.
on a date to be fixed by the registry. That's all.
Item number 8.
This first appeal is already admitted. Why is it for orders?
There's an IA.
There's an IA. What is the IA for?
Additional evidence or documents.
Any objection?
Yes, my lord. We have filed our objection.
All right. Yes, what are the grounds? What documents you want to bring in?
Yes, my lord. In this matter, this is like an application under Order 41, Rule 27 AA, read with Section 151 of CPC, seeking permission to adduce additional documents in filing RFA for setting aside the impugned order dated 17/4/2023, passed by the Senior Civil Judge 2 in probate case number 14 of 2017.
Yes.
Yes, the Senior
Before
Civil
we go
Judge
to the
2
facts, let's see Order 41, Rule 27 once. Yes.
Yes.
Please read.
In this matter, yes, my lord, the probate case was probate by the Senior Judge, Judge 2 in probate case, and then here we want to adduce additional documents because there is to prove that the alleged will is false and fabricated. And after the judgment and order was passed on the judgment and order was passed on 17/4/2023, but after that, through RTI, we have sought information through RTI in September 2023, that is after the judgment and order, and then we came to learn that one of the LSC, in this matter, there is 7 LSC was there, and one of the LSC was already sold by the executor Lian Ming Thanga while before he passed away. He passed away on.
What is the document, ma'am, that you want to bring on record? What is the document?
The documents is that he already on page 72, my lord, that he already sold, and we have he have made an affidavit, and also he already
I'm
transferred.
sorry, but I'm not understanding anything. What are the additional documents? Because what you have to show before the court is that despite due diligence, you were not aware of the existence of these the documents that now you are seeking to bring in record, correct?
Yes, my lord.
So first you have to show me what are these documents, A. Secondly, how and when did you come to know as regards the existence of these documents? Isn't
Okay,
it,
my
Mr.
lord.
Silo?
Yes.
That is
And-
what.
And the most important thing is that whether those evidence they are trying to reintroduce or adduce,
Correct.
is it important for deciding the matter?
Correct.
That is the qualifying.
So that is all. So you first show.
Yes, yes, my lord. This in this matter that Mr. Liang Mingtang executed a will for 7 LSC. 7 LSC, and after the judgment and order, that is the judgment and order was passed on April, and then after the judgment and order was passed, that is on September, through information, RTI information, we came to learn that one of the LSC was already sold by Mr. Liang Mingtanga when he was alive. Okay, and then that means that if Mr. Liang Mingtanga executed a will, he have a chance to custodial or remake his will. Okay, and we want to produce in this additional evidence that after only the judgment and order, we came to learn that he sold, and then he sold to Mr. one of H. Pakunga, and after that we came to learn
He
only
sold.
that. Okay.
Out of the 7 LSEs that were in the name,
Yes.
one of them has been sold to someone.
Yes.
This is what you came to know after the trial court
Judgment
judgment.
order. Yes. Even in the probate case, while the trial was going, we also requested the learned trial court to that the executed will was false and fabricated. And also, my lord, if you turn the page of my my RFA page number 47. Para 10, in the last sentence, that we have make a request that it should be necessary to send the signature, that is the signature of Liang Mingtanga and Lal Dusaka, to the forensic expert for taking opinion for proper adjudication of the case. But however, the learned senior civil.
So you want to bring in the additional evidence of this notary?
Yes,
officer.
yes. And also, my lord, that the respondent passed away. The respondent passed away during the trial, and he was represented by her daughter. And then the judgment and order was 17-4, as said before, and the without taking any heirship, which was represented by she sold it to one person, Mr. Lel Chuanliana. And that is also we came to learn through RTI.
All right, please.
From page number.
You please read your averments from paragraph 2, page 3. Read the paragraphs, please.
Page number 3.
Page number 3 of the application.
Petition, page number 3. From the point number 1. Okay. Did the appellants herein have filed this instant appeal against the impugned judgment and order?
2A, that the appellants are the son. Page 3.
Yes, page 3.
Of the IA.
Sorry. The
It's all
brief
right.
facts.
Go slow. No hurry.
Okay, brief fact of the case is narrated as
Yes,
follows:
yes.
that the appellants are the son of late Liang Mingtanga with his legal wife Siam Liani, and the respondent Van Beni late was the concubine of late Liang Mingtanga. Unfortunately, Van Beni passed away during the pendency of the case, and she has been substituted by her daughter Van Diki. That the appellant's deceased father Liang Mingtanga late had married the appellant's it was supposed to be appellant's mother Siam Liani on 5th December 1966.
So
Under
Siam Liani is the mother.
yes,
appellant's
the appellant's mother. Yes, under the Indian Christian Marriage Act 1872 at Silchar, Assam, and the marriage of certificate bearing registration number dated so and so was issued accordingly, and there was no dissolution of marriage between them till the time of Liang Mingtanga demise, that is 11/9/2009. Number C, that the appellant mother Siam Liani bought a landed property at Selesi from Mr. Tarwala from her for her first landed property in Mizoram, and the said land was demarcated into 7 LSCs. D, that in the year 2001, the appellant's father Liang Mingtanga late starts living with his concubine, that is Vanlal Beni, late excellency, on the landed property where the appellant's mother, Siam Liani, bought from Mr. Charwala. E. That on 26, 2017, Mr. Vanlal Beni late, claiming that she was the legal wife of Mr. Liam Ming Thanga late, and she had filed an application to grant probate of the will dated 22/2/2005, executed by Liam Ming Thanga, and the application was accepted and registered as probate case number 14, so and so. And on date 6/9/2023, Mr. T. Swanliana, so and so, sought an information through RTI to the Land Revenue and Settlement Department
Who is T. Swanliana?
T. Swanliana.
Who is he?
One person, he's one person, I don't know.
You don't have instruction. Okay.
Okay. And from the replying white letter, so and so, the applicants came to know that the suit land LSC number 207 of 1988 and so on, okay, was sold by Vanlal Diki.
In response to the RTI information sought by one T. Swanliana,
Yes,
you have come to know about the 7 LSEs,
yes,
out of which one was sold.
208.
Yes, read.
Okay, was sold by Vanlal Diki to Mr. Lal Chwanliana by executing a sale deed dated so and so, and the same was transferred and mutated in the name of Mr. Lal Chwanliana on dated so and so by submitting sale letter of Mun in Lena Lekha, letter of application for transfer of ownership of land holding dated, and letter dated so and so. It is further submitted that the respondent council has misguided the Land Revenue and Settlement Aizawl, Mizoram by submitting letter dated 29/5/2023 stating that the petitioner, that is Vanlal Diki, has been declared as the legal and rightful owner of LSC number so and so. The impugned judgment and order dated 17/4/2023 has not given any title to Vanlal Diki over the suit lands. Hence, Vanlal Diki has no authority to sell the LSCs. Also, that airship certificate was not issued in respect of the suit lands to Mr. Vanlal Diki. And then the annexure. And
Your averments are not properly, there's no, where are the averments in tune of AA of 27?
because my lord,
What prevented you from bringing on these evidence? Where are those averments? And you don't even know who is T. Swanliana. What is the relation of the applicant with T. Swanliana?
Mr. Swanliana is
The averments are not satisfactory.
is there relative who came to just practice junior, their relative,
Sorry?
the relative of the applicants. Now he's starting practicing in the district court.
How can this court take cognizance of all that? Yes, Mr. Silo, what is
My
your...
lord, this application, if I take your lordship, so that it will be clear, we have to confine ourselves to the CPC, since this is an IA. And, my lord, I have stated in my objection through affidavit at Parat 3, and
Yes,
yes, if I may kindly read your lordship.
yes.
That at this stage, I beg to state that the application for additional evidence filed by the applicant under Order 41, Rule 27 AA is highly and seriously objected by me. This application has not clearly mentioned what are the additional evidence that the applicants are proposing to adduce.
This is absolutely that is going on in my mind.
Yes.
Till now, I'm not clear, except
Yes.
that perhaps one notary officer they want to examine.
That also will go through that. It's only after the pronouncement of the decree that all these
So,
things
but
have happened.
how and where they have to show
They have to
that
show.
despite due diligence, the sale deed was not in the, because if I
And in
understood,
fact, there's no sale deed to date.
No, but perhaps what
It's
I
an
may be,
affidavit. It's
I
just
may
an
be wrong, but perhaps what is trying to be projected is out of those 7 LSEs, 3 has been sold to someone.
one. She
One.
said
One has been sold to somebody. Now that they didn't know. So, and according to them, that sale has been fraudulently done. I think this is what they are trying to say.
No. What they are saying is that the fact is that in 2005, I'm the owner of the land. The deceased is my husband. There is no dispute as to his title to the land. There's no counterclaim in the trial that this land does not belong to my father or they are my sons. That this land doesn't belong to my father. There's no counterclaim at all. So it was fully admitted that the land belonged to the deceased. That's aside. Now, and there's also evidence that me and that deceased, we were married. I'm the second wife. And at the time of leaving my first wife and my sons, I've given them 99% of my properties. All my business, all my land. I kept only one land. That is, this is a farmland outside of Aizawl. That only I kept to myself and my second wife. It was a barren land. We built an Assamtai building together. We lived there together. I was already almost 60 years old when I married my second wife. And we lived there. And I made a will in 2005. I married her in 2001, my second wife. In 2005, I made a will that those farmland we have separated to 7 LSs. And in my will, through the witnesses, I've given her, bequeathed her, stating that I've already given my business, my main residential, and all my properties to my sons and my first wife. Now, after that, in 2009, I died. 2009, I died. Then, my sons, who have never visited me, within 7 days, they filed an heirship certificate to the, claiming that 7 LS.
The plaintiff are the sons.
The sons. Within 7 days of my death, they filed an heirship application. And on one day itself, they were given the heirship certificate. So I filed this thing, appeal. It was dismissed. Although it was allowed, and the heirship certificate was cancelled. So I filed a probate case. Now, the probate case is mainly about the will. It's not about my relationship with the wife, or whether I'm married or lawfully married or not. So whether the will is correct or not. So evidences were taken. They have given chance to adduce the evidence. The probate case carried on for 6 years. And during that time, they have never filed an application for scientific evidence to whether the signature in the will was correct or not. This is only come in the appeal. No application is there, and they have never stated.
And
that,
what is this new additional evidence that they want to?
now they have come now stating that before he died, before my husband died, he sold one piece of the land to some unknown person, and that unknown person supposedly changed the name during the pendency of the child, the case. In 2000, we will see that in 2002, just while the case was, I believe it was pending, he had, without any sale deed, he had simply went to the revenue department, and they have not annexed the sale deed also. He just said, I've already bought this land, and please put it in my name. So we don't know that there was a sale deed. They have not produced any sale deed. Now, out of the blue, this one piece of land was put into this third person name, right? And that person, that was 13 years after I died. 13 years after my husband died, one piece of land was converted to a third party name. And that person made an affidavit not in 2002, in 2023. Last year he made an affidavit that I bought this land, so and so, before he died.
This affidavit was brought in evidence.
Now they're trying to adduce that evidence. But what is the use of that now?
And this case presently is about the
will.
About the
Will.
Probate.
Yeah. And that is what I've stated. My lord, if I just take your lordship to para 7 of my objection.
Just read para 3 first.
Yes.
Okay. Your objection.
This application has not clearly mentioned what are the additional evidence that the applicants are proposing to adduce that are necessary or indispensable for this appellate court to pronounce judgment in the connected appeal. In fact, the judgment and order dated so-and-so granting probate of a will challenged in the connected RFA has been passed by the learned senior civil judge to Aizol after both parties have adduced their respective evidence on record during the proceedings of the probate case. All evidence that is required by the appellate court to enable it to pronounce judgment in the connected appeal is already on record. In this regard, the apex court has held in a category of cases that the true test for admitting additional evidence in appeal is whether the appellate court is able to pronounce judgment on the material before it without taking into consideration the additional evidence sought to be adduced. As such, there is no substantial cause for admitting additional evidence at this stage. In this regard, my lord, I'll just take, to make it clear, I'll just take a logic to the apex court judgment in this matter.
Yes.
It is 2015, volume 17, SCC 703. This has already been settled, your lordship. A. Andisami Chettiar versus Saburaj Chettiar.
Yes.
And if I may take your lordship to page 718. Here the section is produced. Section 27, production of additional evidence in the appellate court. Order 41 Rule 27 is produced herein, your lordship.
Sorry?
And in the first line, the relevant section has been produced.
Yes, 27.
Production of additional evidence in the appellate court.
Yes.
My lord.
Yes.
So if you go to para 12,
Yes. Please read from paragraph.
from the opening words of sub-rule 1 of 27 quoted above, it is clear that the parties are not entitled to produce additional evidence, whether oral or documentary, in the appellate court, but for the three situations mentioned above. The parties are not, this part is important, the parties are not allowed to fill the lacuna at the appellate stage. It is against the spirit of the court to allow a party to adduce additional evidence without fulfillment of either of the three conditions mentioned in Rule 27. In the case at hand, no application was moved before the trial court seeking scientific examination of the documents. This is clearly the case. Nor can it be said that the plaintiff with due diligence would not have moved such an application to get approved the documents right upon by him. Para 13, in K.R. Mohan Reddy versus Network Inc., this court has held as under. The appellate court should not pass an order so as to patch up the weakness of the evidence of the unsuccessful party before the trial. But it will be different if the court itself requires the evidence to do justice between the parties. The ability to pronounce judgment is to be understood as the ability to pronounce judgment satisfactorily to the mind of the court, but mere difficulty is not sufficient to issue such direction. And in, my lord, in the next page, para 15.
Yes.
In N. Kamalam versus so-and-so, this court interpreting Rule 27, Order 41 has observed. The provision of Rule 41, Order 41, Rule 25 has not been engrafted in the court so as to patch up the weak points in the case and to fill up the omission in the Court of Appeal. It does not authorize any lacuna or gaps in the evidence to be filled up. The authority and jurisdiction as conferred onto the appellate court to let in fresh evidence is restricted to the purpose of pronouncement of judgment in a particular way. Para 16. In the Union of India versus Ibrahim Uddin, this court has held as under. Para 49. An application under Order 41 Rule 27 CPC is to be considered type of hearing of the appeal on merits, so as to find out whether documents and or the evidence sought to be adduced have any relevance bearing on the issue involved. The admissibility of additional evidence does not depend upon the relevancy to the issue on hand or on the facts, whether the applicant had an opportunity for adducing such evidence at the earlier stage or not. But it depends upon whether or not the appellate court requires the evidence sought to be adduced to enable it to pronounce judgment or for any other substantial cause. The true test, is what is important, your lordship, therefore, is whether the appellate court is able to pronounce judgment on the materials before it without taking into consideration the additional evidence sought to be adduced. So, my lord, in the report,
all the evidence that was required to see if the will was genuine or not is there. This is a probate case. This is not a dispute of title case. They have not filed any counterclaim.
Here, what is to be seen is whether the will is genuine or not.
Genuine or not. And for that, they could have filed an application asking for, if they say that the signature of the testator is fake, they should have filed an application like to see whether it is right or not. They did not do that. They cannot once again come here and like all this. He sold one land before. They stated that I sold the land in 2009, but I made the will in 2005. Maybe I did not make a second will. So that is
This land and the will is dated?
2005.
Give me the date.
22 February
22
February 2005.
2005. And the land was sold when?
They allegedly
2009.
and I died in 2009.
And you died 2009.
2009. So that is
Was sold on 28th March 2009.
28th March is what? Which date?
2009, yes.
That is the date of?
20 March.
That date of sale.
Yes,
Or
yes,
died.
sale.
that is their
And he
affirmation
sold- he sold
without
on-
any
No,
document.
Mr. Silo, I'm just recording the date. I'm not accepting it. When, according to you, it was sold?
Sold on 20 March 2009.
203. Okay.
Okay.
And date? Do you have the date of the death of the husband? When did the husband die?
The husband died on 11/9/2009.
All right.
Regarding that, my lord, if I may kindly take a
But
lordship.
you see, Mr. Silo is correct. What is the relevance of this sale in a probate case? And you have not brought all this earlier. Now, in this application, also you are not satisfactorily stating the reasons as how, when,
Because, my
nothing is
lord-
given, and what is the importance. Because before the court, what is to be decided if whether the will is genuine or not? How is this relevant?
Because, my lord, if the if Mr. Liang Mingtanger really executed will, they have a chance. My lord,
But
just one-
that you see,
Oh.
that you have already got all your chance. The trial, the will probate case had, you got all your chance to show whether the will is correct, not correct, fraudulently done, not done, everything. You had all your chance. Now, after you failed, and the appellate, at the appellate stage, you want to bring all this. And that also, what relevance? You want to show that out of the 7 LACs, 1 he has sold to someone. What is the relevance of that? The rest, and if this court, if at the end of the day you succeed showing that yes, out of 7, 1 has gone, but that has gone in 2009. Will is of 2005. The will doesn't become obsolete. The will continue. Maybe before, after he sold, he didn't get the time to make another will confining it to the remaining 6 LSC.
Pass away within 2 months.
That can, it can be, isn't it? There is no, I don't think, correct me if I'm wrong, but there cannot be a law saying that if after making the will, you have made some changes which is part of the will, the entire will go up. That cannot be. Today I may make a will, I have 5 houses. I may make a will today. After a few years, I might think, okay, out of the 5 that I have given it to A and B, 1 I will sell because I need it, I need money. I can do that and I have sold it. But before I could change the will, I die. Now can you say that that will is not
yes,
genuine?
Your Honor.
No. Are you following what I am saying?
Yes, Your Lordship.
And here, your whole case is a probate case. How is this relevant? Of course, if you would have bought it at that stage, that was a different thing. You haven't brought it. Now after so many years you want to bring this evidence. And
Yes.
that also on a very vaguely. The above ones are very vague.
My lord, just one thing. Suppose did that the testator Liang Mingtanga passed away on 2009. After he passed away, his son, that is the appellant, they have applied for heirship. And after the heirship was issued, and then the respondent have appealed RFA, and then it was set aside the heirship. And after that, if the will is real, and why not they filed a probate case? And they haven't filed a probate case after when the heirship number when the first heirship was set aside in 2009. The respondent have not filed probate case, and so if the respondent have not filed anything, like a probate case or something like that, and then again the appellant applied for another heirship, and then the heirship was again issued, and after the heirship was issued again the respondent have applied for RFA, and again it was set aside. Heirship was issued 2 times before the probate case was filed by the respondent. If it is not fake, why not file? Why not file when the first heirship was set aside? And
My lord, hundred
after,
days are
the
for the
sec-
lower
after,
court.
after 2 heirship was issued to the appellant only, and then the respondent have filed the present probate case. And then even in the probate case, the signature there in the written objection, we have annexed the real signature of the testator and the witness. One of the witness signature was also different. And then we have prayed the lower court to send the signature to the forensic department, but the learned trial court failed to do so.
See, those are your grounds.
And
You
also,
are Miss Fanai, right?
yes,
Ms. Fanai, those are the grounds perhaps you have taken in the appeal. Now the question is about adducing additional evidence. So this court will confine to that, and the test is laid down in the case of Ibrahim Uddin. Do you have a copy of the judgment cited by the other side? Are you having a copy?
No.
So, Mrs. Silo, you have a copy? Please give it to Ms. Fanai. And Ms. Fanai, kindly come to para 16 of that judgment. You have an extra copy?
Yes.
Why you did not give it to Ms. Fanai? Yes, para 16. Please see. You can read it loud for all of us.
okay. An application under Order 41 Rule 27 CPC is to consider at the time of hearing of appeal on merits so as to find whether the documents and or the evidence sought to be adduced have any relevance bearing on the issues involved. The admissibility of additional evidence does not depend upon the relevancy to the issue on hand or on the fact whether the appellant had an opportunity for adducing such evidence at an earlier stage or not. But it depends upon whether or not the appellate court requires the evidence sought to be adduced to enable it to pronounce judgment or for any other substantial cause. The true test, therefore, is whether the appellate court is able to pronounce judgment on the material facts before it without taking into
materials.
consideration.
On the materials before it.
Yes, consideration the additional evidence sought to be adduced. Such occasion would arise only if, on examining the evidence as it stands, the court comes to the conclusion that some inherent lacuna or defects becomes apparent to the court.
So that is the test. That is why I am putting this question to you. That what is the essence of these documents for the pronouncement of the appeal? where the order granting probate is under challenge, correct? The order granting probate is under challenge. And in that will, there are 7 LSCs. You are only saying that 1 out of the 7 LSC, you are saying allegedly has been sold out of the 7. But the 6 are there, and this will is dated 2005. And the alleged sale date is of 2009, just before the person died.
Yeah, 5 months.
I don't see any relevance.
My lord, suppose if I make a will, suppose if I make a will today on September, or if on December again I sold one of my land, and then I will come to know that, like, yes, if now I sold one of my land to other person, so I have to remake my.
Yes, but you see, that's why I'm saying it's a human thing. You have, of course, you have made a will and you know it, but you were not expecting that you would die in the next 5 months. You see, you were thinking that I will change, but before you could change, you died. It is very human.
Yes, it's
And most important, what I am thinking is that whether that second sale is there, not there, it has nothing to do with the validity of the will, because you had all the opportunities. The trial court has gone into all this aspect and found the will to be genuine and granted probate. Correct? On that you are finding appeal, that is on merit. But this part has nothing to do at this stage.
okay.
If you would have brought it at that stage, that was a different thing. But now, at the appellate stage, what is the relevance? I am on that, because if I have to allow this, and you are not clearly stating what is this evidence that you want to bring in. You have not said A, B, C, that this particular document you want to bring in. That is also not very clear from the reading of the paragraphs of your application. And the other side have taken that objection, that your application is vague. In fact, when we were reading it together, that time also I had pointed out, where are those averments about due diligence? When did you come to know? What is the relevance? Those things are missing. And what is this evidence? That is also I can't find, except in one para you have said some notary officer about that sale date. Very well. You see, Ms. Fanai,
Yes.
let's admit, for the sake of arguments, let's admit that the sale date is correct.
Okay.
How does it affect the will? The will is not made after this. Yes, you would have had a case. If this sale was in 2005 and in 2009 a will is shown to have been made where this land is also included, then one could have said that prima facie it looks that the will is not genuine, because a land which has already been sold is included. But here it is vice versa. It is nothing unnatural. We all may make a will today, and tomorrow there may be some change. Just because there is some change and I did not rechange my will, my first will be invalidated. Think of it. This is what is troubling me. Because if the answer is that yes, it will invalidate the entire will, then of course this evidence is essential, which perhaps was not before you at that time, and now you have come to know and you want to bring it. In that case, it will be the duty of the court to allow it and bring it on evidence.
And my lord, if I may, on top of that, the person who have bought the land should be made a party. They have not made any party, and that person should have filed an appeal, not them. Or that person should have filed a cross appeal, or
Because his land is part of this.
yeah. So, but that person has not been included in it. So how can that? There's no grievance on their part.
Because, my lord, yes, we didn't know that the testator has
It is
sold
not
it to
that sad
this
that I have
person.
bought the land from my father before he died.
Sorry?
It is not that sad that they have bought the land from my father. I bought the land from my father before he died. So this land should not be. So there's nothing titled.
Sorry, Mr. Silo, I could not appreciate
No,
your
it
last
is
part.
not a fact that the parties here say that since I bought the land from my father, supposing that bought the land, then they can say that my father should not include in that. This is not the case. It's just a third person. So that third person,
He is not before the court also.
not before the court,
And he has not even challenged anything.
and not challenged. The probate case was started in 2017.
So if it was sold to him in 2009, then there should have been some application.
For implement, or whether he should come forward and say that nothing of that sort was there.
There is an LSE in his name in respect of this
In
land.
that point, my lord, that also we've done. If I may take your lordship to para 7, it will be very clear.
Para 7 of?
My objection, affidavit objection.
Yes.
But may I kindly read? That with regard to the statement made in para 4 application, I beg to state that the affidavit cannot be regarded as a legal instrument of sale of immovable property, nor can it be the basis for acknowledging a sale of immovable property. A sale of immovable property must be executed only by a sale deed duly registered as mandated by the relevant landlord. Therefore, the purported LSC so and so issued in the name of H. Pakuma in the year 2022, after 13 years from the death of the owner, transferring S. Remington, who died in 11.
So this LSE, what is this, 2022?
It was transferred to the name of the third person in 2022.
So that transfer they are showing from that affidavit.
Yes, from the affidavit. He said, I bought the land in 2009 and I transferred my name in 2022. After, my lord, and 2017 was the probate case. That point of time it was still not transferred.
After pending.
During the pendency. After 13 years from the death of the owner transferee, Shri Lemingtara, who had died on 11/9/2009, and during the pendency of the probate case, in which the said LSC was included in suit, is wholly illegal. In fact, it is clear that the LSC was issued in favor of by dishonest and underhanded route without following the procedure for transfer and mutation of land settlement certificate. Hence, it is humbly prayed for the Honorable Court to pass an order requiring the applicant to prove its legality.
Legality, I have no doubt in my mind. There cannot be a question of legality. Yes, a question might come because this third party now has also come in existence. But then during probate case, his name was not there. Otherwise, that time he should have been also, a notice ought to have been gone to him, because by then if a part of the land has been sold, but he has never, it is for him to come forward. He has not come forward, Mr. Naik. He hasn't come forward.
And the thing is that how can he transfer the land in his name in 2022 when there's no transfer? The transfer type.
Where is the trial court's order? Page? In the IA? In the IA?
Roman number?
Is it annexed in the IA?
Oh, sorry.
No, my lord, in the
Main
RFA,
case?
in the RFA.
RFA.
Yes, where?
Second page.
Yes. This is the 17,423,
Yes, my lord. 1742.
Senior Civil Judge 2.
Yes. All the evidences were taken, and they have the defendant then also have adduced. So, my lord, regarding this IA, I don't think you can stand, your lordship. My lord, issues were framed by this court, by the lower court.
Yes. Which
And-
page?
Page 18 of the judgment and order, issue number 2.
1 second, please. issue number 1, whether the will is the last will. Whether the will be probated as applied by the plaintiff. It's found to be genuine. Ms. Vinay, I don't think. Anyway, I'll resume in 5 minutes. Till then, you may think over once again.
Yes, my lord. Anyway,
After-
if your lordship allows, I will withdraw with liberty. With liberty to file afresh.
File afresh.
Yes.
Okay, I'll think over your
Okay.
prayer. 5 minutes, I'm resuming. Yes, Mr.
Yes,
Naik.
my lord, if your lordship allowed, let's say IA to set aside and then to hear on the merits to be fixed like next week. Or
So I will, you are withdrawing or I will
set aside the IA only.
set aside the IA means?
Yes,
You are leaving it to my wisdom.
yes. Yes.
Oh, then I'll have to give a detailed order. Or, so are you withdrawing or you're not withdrawing?
Okay, my lord, I will withdraw.
I don't want to bulldoze you, huh? Because if you are,
Okay, my lord, withdraw with liberty to file afresh.
no, withdraw only.
If she has due evidence, she always kept coming with another argument.
Correct.
There's no liberty.
If I can otherwise dispose it off, I think that would be appropriate because you don't have instructions to withdraw. Do you have that instruction from your client?
Yes, my lord.
You have it?
Yes.
Okay, then it's all right. In the IA, heard MS Penile Learned Counsel for the applicant and stop. Also heard Mr. Jonathan L. Silo, Learned Counsel for the respondent. Stop. This is an application under Order 41, Rule 27, within bracket AA, read with Section 151 of CPC, seeking permission to adduce additional documents, evidence in the accompanying regular first appeal, i.e. RFA number 24 of 2023. Stop. MS so-and-so Fenile Learned Counsel for the applicant submits that she has received instructions from her client not to press the current interlocutory application and accordingly makes an endorsement to the said effect. Stop. In view of the aforesaid endorsement made by the learned counsel for the applicant, the interlocutory application stands dismissed on withdrawal.
Oblige.
In the RFA, what is the stage of the RFA?
Has just been admitted.
So is it ready? Is it ready for hearing? Is the paper book?
No, paper book has to be called.
Paper book will probably be required.
Yes, my lord.
So case records have come. Case records have come. Not yet. Was it called?
The purpose is because of the IA, pending the IA.
No, I think the 19.7 is the order of admission. Admit. Case records would be required. No, it has not been called till now. Correct?
Yes, my lord.
All right. In the main, say, let the case records be called for from the court of
Senior Civil Judge.
Senior Civil Judge 2. Aizal?
Yes.
Aizal. List after, and then you say that let registry upon receipt of the case records prepare paper book and furnish the same to both the learned counsels. List after 4 weeks on a date to be fixed by the registry.
Oblige.
I may be given a liberty in making mention right now because I'm required to the next call.
In which?
Regarding the item, part 2, the last item for hearing, I've talked to Miss Mary and she said that if the matter can be listed after 20 of this.
In the part 2?
Part 2. All the item left on part 2.
Item number?
I think it's 8.
All right. You'll be excused.
Pleasure.
Item number 9.
In which? How to?
My lord, re-
What
records
is
have been
this?
called in the
This is a criminal appeal.
criminal appeal against the conviction under the PC Act.
PC Act.
Yes, my lord.
LCR, case records have come. Paper book
It
is
has been
re-
called, my lord. It has been called in the last proceeding.
So has it come? Case records? Has the case records come? Huh? Note. It may be mentioned that it appears that the case records is same as regards criminal appeal number 4 of 2024.
Yes, my lord. There are
So-
similar matters.
So then, can you find out when is criminal appeal 4 listed? Are you aware, Mr. Pauto?
Yes, I am aware, my lord.
When is it fixed?
That is out of my knowledge, my lord. But
Sorry?
that I don't know, my lord. But there are similar cases.
Is
criminal
MS
appeal-
Linda appearing in this matter? Ms. Linda, this case records is common for the office note says that the instant case shares same case records with criminal appeal number 4 of 2024.
We challenge the same judgment.
So it will be, then the case records may have come in criminal appeal 4 of 24. When is that criminal appeal fixed?
My lord, I'll have to check. It may kindly be taken together with 3, 4, and 5, my lord.
Yes, then I'll say list this along with so and so.
That's fine, my lord.
Give the numbers. Let this criminal appeal be listed along with criminal appeal number 4 of 2024, comma, any more?
No, my lord.
That's it?
Yes.
So and so.
3, 4, 5 are another criminal appeal, lordship.
Criminal appeal number 3 of 24,
Yes.
comma, criminal appeal number 4 of 24, comma,
5 also.
criminal appeal number 5 of 2024. Huh? No idea when those matters are fixed.
Yes.
All right, then I say list along with. So whenever they are fixed, it will come.
Yes, lordship.
Item number 10.
NDPS. First time
LCR has come, my lord.
has come.
Yes.
But where is, nobody is appearing for the appellant, no name is shown.
No name is shown. I think this is jail appeal, my
So we'll have to appoint someone.
lord. Yes.
Amicus.
Amicus.
Mr. Joseph, if you're not too busy, then NDPS otherwise LCR has come, right? So paper book also has to be prepared. Mr. Joseph L. Ralde is appointed as an amicus curiae to represent the appellant in the instant criminal appeal. Stop. Let the appeal memo along with the relevant records be furnished to the amicus, to the learned amicus curiae by the registry. MS Linda, learned PP, submits that the case records in the meantime have been received from the trial court. Stop. Let registry prepare the paper book and furnish the same to both the learned counsels. List the matter after 4 weeks on a date to be fixed by the registry.
Item number 11.
Yes, your lordship.
21C.
Yes, your lordship. 21C.
First date.
Yes, this is the first time.
So, I'll issue notice.
Yes, my lord.
Issue notice MS Linda, Leonard PP, accepts notice on behalf of the state respondent. No formal notice. Extra copies within the course of the day. Scan LCR is required.
No, my lord, charge, it's already charged.
List again on.
Next week,
Give a date.
Thursday, no,
All right. List on such and such date.
My lord, the co-accused has been released by the order of this honorable court.
Very well. It is 21C. So MS Linda has a right.
Right, your lordship.
Correct.
But since if this can be taken up by your lordship, because
By?
before your lordship.
I had dealt with the earlier.
Yes, your lordship. The co-accused has been.
Yes, 7624. This is there in this.
Lordship.
The co-accused, I think, was not named, or I think he is the driver.
The present petitioner is the driver, and the co-accused who has been released was the owner of the truck.
The owner has been released.
Yes, your lordship.
We can have it on Monday. Monday, because you have a look at it. It will be list. This bench is available on Monday. List on Monday, huh?
Obliged, your lordship.
Item number 12.
First time.
it's also first time.
Okay. Doctor has made me burn midnight oil. One thing when I need some clarification from you both is, what is this proceeding heirship certificate like? Is it like a succession proceeding or what? So what is it like? Because you see, Mr. Joseph, why I'm asking you this question is, there are also decisions of the apex court where it has been said in a case of a succession certificate, there the court is not deciding the ownership. The court is only deciding the line of succession.
Line of succession.
Correct?
Yes.
Therefore, the court doesn't go into the predecessor's title, ownership and all that.
That is correct, my lord.
Correct?
Yes. That
So, therefore, now what is important is to find out what is the nature of the heirship certificate proceedings. That is important, because you have given those decisions, which is also correct. But they will be applied only in that situation where the court is deciding the ownership. Now, if heirship proceedings are akin to a succession proceeding, then it is merely deciding on the basis of the material that is already shown, that the husband is he is the holder of the land settlement certificate, and on that basis the wife is claiming. Correct? And to that particular law is also there, which the trial court has, the first appellate court has also relied. Because you see, Mr. Joseph, it is the remand or the retrial has to be very cautiously exercised. It cannot be just in a routine manner only when the facts are such, you see. So it kept me thinking. Otherwise, I was quite sure till yesterday after hearing you both that, probably it would be best to send it back.
Yes.
But suppose that question is not involved, then
from my little experience, my lord, very less experience, my lord, from
No,
how
no,
we
you are
have,
experienced lawyer, Mr. Joseph. This court has been seeing. Yes.
from how I have handled heirship matters, my lord. One in Lunglei, my lord, that case is now pending in this High Court. Now that heirship case, my lord, even though it originated as a heirship case, the issue has become a complete service matter. It's with respect to pensions. So in that case, my lord, one of the issues that has arisen is not so much about whether there is only inheritance. It's about the service rules.
Mr. Joseph, we will not go by all that.
No, so I'm just trying to explain.
You see, Mr. Joseph, I think what you both need to assist this court is to show me the relevant law.
Yes.
Number one, under which the heirship certificate is applied, and what is it? That will clear everything. How is it given? Isn't it? Because what I could find, read para 17 from this decision.
Succession certificate is granted for a limited purpose. A court granting a succession certificate does not decide the question of title. A nominee or holder of the succession certificate has a duty to hand over the property to the person who has a legal title thereto. By obtaining a succession certificate alone, a person does not become the owner of the property. It's slightly different, my lord, because there are two applications. In Mizoram, one is succession certificate application is there. It exists.
It is there?
It exists, yes. And this is heirship certificate application.
So that is why I'm asking
yes,
you.
Yes, yes,
The question that because I want to be clear on this.
Yes.
So that is why, what is this nature of heirship
Yes,
proceeding, you see?
So in heirship, my lord, I'll just explain. So heirship, if I'm wrong, let my learned friend correct me, my lord. I don't want to misguide the court, my lord. But my experience is there is one case in which the heirship case, which originated as a heirship case, my lord, has become a full-blown suit.
Yes.
The relief we have prayed is not only about the heirship. We have prayed for mandamus. We have we have prayed for a lot of things, my lord.
Yes.
So it has become a entirely different.
No, but this is covered under the Mizo Marriage, Divorce, Inheritance of Property Act.
Yes, that also will come into play, my lord.
Then chapter 8.
Yes, that is
31. On the death of the head of the family, the wife will automatically become the head of the family if she remains a chaste widow and looks after the welfare of her so and so. Now, is this what is relevant or? And of Mizo customary law of inheritance, that will come. See, this is what I'm not being able to get a direct answer from the reading of this. Under what provision in heirship certificate is given? Because the form, I got hold of the form. This schedule. This is the form.
Yes.
Correct.
Yes.
And this refers to the Mizo Marriage, Divorce and Inheritance Property Act.
Yes.
But the section is given blank here. So I don't know what is the section. Just have a look. I think this is the form. Correct.
Yes.
Should just have a look. I think it is applied under this form. Correct. Now this is under what provision? Just go to that pink flag. I think it is under that pink flag. Is it? Just look at the pink flag. Yes.
Yes.
This is how it is. So that means here what is being decided? Because if ownership is in question, then
no, ownership still comes, because ownership has to be there, relevant, my lord, because it has to be the property of the head of the family. It's like will, my lord. You cannot make a will if it is not your property. Even if you make a will, my lord, after the probating of the will, the question still remains even if it's probated, for instance, or even during the probating of a will, one of the question that comes up is, is he entitled to make the will because it's not his property? It is like this, my lord. Unless it's a property of that person, you cannot claim inheritance of that property on the basis of ownership of that person, if it is not his property, my lord. Because this succession is slightly different, and in Mizoram, my lord, succession usually happens when with respect to money issues, like in the bank and all, we have money. So usually for those purposes, they apply for succession in Mizoram, my lord.
Any provision for succession?
Succession, my lord, as
Under
far
the
as I know,
customary
law
law?
is applied, my lord, for succession.
My lord, this with regard to, so far as my little knowledge is concerned, my
We
lord.
all are, this is, we already now become academic question.
My lord.
We're trying to understand.
My
Yes.
lord, before this Mizo Inheritance of Property Act 2004 came into existence, the earlier act applied among the Mizo society is the Inheritance of Property Act 1957, my lord. So,
First it was Mizo.
Mizo Inheritance of Property Act 1957. But that particular act was repealed after
Mizo customary laws 1956. No.
Inheritance of Property Act.
Let me take a note of it. Inheritance of
Property Act.
that was the first one,
That was the earlier one, yes, my lord.
and that got repealed.
That got repealed
And then,
after the 2014 Act came into existence.
which is the 2014 Act, the marriage,
The Mizo Marriage, Divorce and Inheritance of Property Act.
and this case is going to be covered under. I think this case will be covered by the Mizo divorce. Is it after 14 or before 14?
This is before 14.
So then
yes.
the relevant law will be the inheritance of.
Yes,
Huh?
my lord.
You have that act?
But that is not a comprehensive act. That was not a comprehensive act.
No, but I'm trying to understand. Is this one, the Mizo District Inheritance of Property Act 1956?
That is correct,
That
my
is the
lord.
one?
Yes, that is correct.
So in your case, this is the act which is applicable.
My lord, because by the time of applying the heirship certificate, it was
Under
in-
this, anything about how it is done? Probate means the copy of a will. Probate is given.
It's only for probate, my lord. That was only applicable to
You know,
probate.
there was one case, I think you were there. One second appeal, I think.
Yes,
Were you
we
there?
have one. Yes, my lord.
There,
We have
I think I
this
had
case.
recorded something about how, because about the record, and one has to show that there is something on record, and I think I have referred some registration law or something. Is there any local registration law?
As of today, there is.
There is?
One. It's a new one, yes.
It's a new one. Because here nothing is given about heirship.
But usually, my lord, when applying the heirship certificate before the court, usually that particular act was relied upon.
This one.
Yes, my lord. The principle is exactly similar like the application of succession certificate. So when applying the succession certificate, it was the main issue is with regard to the entitlement of the applicant for inheritance of succession of the particular property. So that procedure was already exactly same with regard to the procedure applied in the process of heirship certificate, my lord.
So prima facie, even I share the same opinion that it appears that they are
My lord.
similar proceedings.
Yes.
Because here you are only deciding who are the legal heir and to
Yes.
whom you will grant that.
But in heirship, my lord, you become the rightful owner and title holder. But in this succession, my lord, in this Supreme Court judgment, it says that succession certificate alone, my lord, does not give ownership and title.
Now you show me that on the basis of the heirship certificate you become the owner. From where? Which
My
law?
lord, there are plenty of judgments, my lord. And in fact, this is, my learned friend will not dispute this, my lord. Once you have heirship certificate, my lord, you are
Which
considered
is
to
the
be.
judgment dealing with that? Just give me one citation that it determines the ownership.
For that, my lord,
You see,
have to
for me to, if I have to apply to that decision which you had given, you have to show me that this is deciding ownership.
Ownership and title, yes.
Correct. This is why because I am not aware
Correct.
of the
Correct.
heirship proceeding, because this is something which is not there in the other states, right? This is in the context of Mizoram, correct? This is-
Yes, correct.
So you have to assist me in this, because the question now comes to that. Joseph, sorry, LC, give this to Mr. Joseph. Read the paragraph that I have indicated here, Mr. Joseph.
Paragraph number 8. In our view, the High Court as well as the Civil Court have acted illegally and with material irregularity in the exercise of their jurisdiction in dismissing the suit on the aforesaid preliminary issue by holding that after the probate having been granted by the competent probate court and affirmed by this court, the Civil Court had no jurisdiction to proceed with the suit. Paragraph 11. As noted herein earlier, the suit for declaration of title and injunction has been filed by the appellant inter alia on the allegations that the suit properties are joint family properties of Hindu undivided family, of which the appellant and his two brothers Hardial Singh Dhillon and Harbans Singh Dhillon, mother Surjit Kaur and unmarried daughter Amarjit Kaur are members. It has also been claimed by the appellant in the suit that by utilizing the income from the ancestral agricultural land, various properties including the suit properties were acquired. Such being the allegations made in the plaint, which can only be decided on trial after parties are permitted to adduce evidence in respect of their respective claims, it is difficult to hold that only because probate of the will of late S. Kirpal Singh has been granted, the suit for title and injunction must be held to be not maintainable in law. It is well settled that the function of the probate court are to see that the will executed by the testator was actually executed by him in a sound disposing state of mind without coercion or undue influence, and the same was duly attested. It was therefore not competent for the probate court to determine whether late S. Kirpal Singh had or had not the authority to dispose of the suit properties which he purported to have.
That ownership is not also
In
a
the will.
question in a probate case.
But in heirship, it is.
So you see, two authorities now I have given to you.
Yes.
One in respect of succession,
Succession.
and this one is in respect of probate.
will.
In both, while dealing with these two areas,
Yes.
the court is not concerned.
With the ownership and title.
Correct.
But in heirship, my lord, it is.
So you
I will
have to-
provide, my lord. Monday, I think we'll have to
Yes,
take time.
Mr.
Yes,
Joseph,
yes.
you will have to satisfy
Yes,
me
yes,
that otherwise from day one I was with you.
Correct.
Because it defies my logic ki without going into the predecessor's interest, when you have raised an objection, how it can be given.
Yes. Because
Correct.
the scope of heirship might be more limited. Yes.
Yes.
So I'll check, my lord.
So
because-
just
yeah.
satisfy me on that,
Yes,
that while dealing with an heirship certificate, what is the procedure and what is being decided?
Yes,
Is
correct.
it the ownership?
Yes.
You see, if the ownership is being decided, then
Yes.
of course,
Yes.
the predecessors, how it has come, has to come in.
Yes.
Specifically in a situation where you are raising an objection.
Yes.
Now, in that situation, I have already expressed my mind, I am going to send it back
Yes.
and give you both the chances.
Yes.
But suppose that is not a
Yes.
issue
Yes.
relevant,
Yes.
then there is no point of sending this matter back.
Yes.
You will have other remedies.
Yes.
Your
Absolutely.
client is not remediless, Mr. Joseph.
Yes.
He will have to take appropriate remedies.
Yes. But in Mizoram, my lord, on prima facie, I think my learned friend will not disagree with me on this.
Let-
we will take time, my lord. We'll take time. But I will just say,
Let us be clear.
let us be
Let
clear.
us be clear.
But in heirship certificate, my lord, once my learned friend's client is given heirship certificate,
she becomes the owner.
There will be res judicata. It will be part on my part to claim ownership and title,
You
independent
show me,
of the heirship.
You show me all this.
Yes, 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 yes.
That is the only thing I think which you need to now show me, whether it is deciding ownership.
Ownership, yes.
Because like probate you have seen,
Correct.
their ownership title is not being decided.
Correct, correct, correct.
It is only about the will.
Correct, absolutely.
Somebody else might say, no, this person who has willed it out is not the actual owner.
Yes, 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 yes. It's not a comprehensive
It
suit.
is not.
Yes.
So what is the objection? Heirship granted.
Correct.
Nothing. And if an objection is given in your case, there is no pleadings.
Yes.
It just call for evidence
Correct.
and decide it. Now that doesn't convince the court that this is like they're deciding the ownership. They're just merely seeing whether that particular person was holding the certificate in his name. If yes, the certificate is there, who are his legal heirs? They're only deciding that. Otherwise, it should have been converted like a regular suit
Yes.
where both parties ought to have been called for filing their pleadings.
Correct.
This thing should have been
Yeah,
done.
yeah.
And you see, if these are not being done, I may lay down
Yes.
the precedent, because this cannot continue like this. There has to be some procedure that has to be followed. CPC has to be followed now that it is applicable, isn't it?
My lord.
Okay, but I don't know, I may be wrong, but the all the heirship certificates till now that I have dealt, I find it is always like this. And I do not also understand how notice cannot be sent. I think there is one decision also from this bench now as regards the notice. I have seen at an appellate stage the matter has been sent back by saying to hear the affected party, because you miss the advertisement on many occasions. Advertisement cannot take the place of
Some people put the advertisement in some small local newspapers.
yeah, so that cannot take place of notice, and notice has to be given to the affected parties, isn't it?
Yes. Yes.
Anyone might come and say,
In fact, they should implead them in the original suit. itself.
absolutely.
Yes.
This is what I feel like. So, given a chance, definitely this court at some point will lay down all these strictures, because it affects. In fact, first they should give a list who are the legal heirs. If there are 3 legal heirs, one has applied, the other 2 automatically has to be impleaded and notices has to be gone. This is how it should be, I think. No?
My lord, in that regard, I'd like to mention one of my experience regarding the challenge of one heirship certificate. I challenged before the single bench by preferring first appeal. Because the summon was not issued and the advertisement was not made to the local newspaper, then the single bench set aside the heirship certificate and remand back. And after that, the learned council don't want to proceed on the heirship certificate asset by conducting a fresh trial. So instead of that, they are filing the title suit. So by filing the title suit, the fresh trial was commenced before the trial court. So that is what we are doing.
And in that fresh trial, what was the relief sought? Declaration.
Yes, declaration where there are
Title.
pleadings, specific pleadings.
That is
like,
what, those things have to be
yeah,
there.
those things has to be
In
there.
fact,
Yes.
the moment an objection comes, it needs to be converted into a regular suit, and all the provisions of the CPC should be followed in stricto sense. I think that
Exactly.
is what
Yes.
needs to be done. Isn't it?
Yes, my lord.
We are also, my lord, your lordship has come at a time when Mizoram is gradually like creating these laws. I mean, it's coming into more formal sense. So your lordship is pointing out this thing which is not adequate, my lord. It's true. Your lordship has raised a very pertinent point, but it has always been our assumption, my lord, just based on assumption. This is, I think, that once you're declared legal heir, you become the owner. I think my learned friend also will agree to this fact
No,
at this
see,
stage.
assumption cannot take place
Correct,
of
correct.
law.
We will
isn't
we will
it?
try to find something, my lord.
Now, in this case, this has become a very pertinent question.
Yes.
Because that will decide the course of my order,
Correct, correct.
isn't it?
Yes. Absolutely.
So anyway, when do you want it?
My lord, let's do it on Tuesday or something because we'll take some time to research.
Yes.
I think my learned friend also.
Because I shall probably, this bench is only available next week
Exactly.
here, and this matter is not a matter which can be conducted in the video conferencing mode. So I would like the to finish the arguments and while I am at station.
Yes.
Uh,
My lord, this judgment, should I give it back to you?
yes, please. You may have a.
I'll take a picture, my
You,
lord.
you take a picture so that and give it to both of you can have a look at it. A pertinent question as regards the nature of the heirship proceeding has arisen during the course of hearing. List this matter on such and such date to enable the learned counsels appearing for both the parties to address on the said issue, on the said question on the next date of listing. All right?
Part 2, item number 8.
Those two questions.
There's no one, my lord. No one's left.
Part 2. Okay, next week. Is this the one which Mr. Pauto? Huh? No, Mr. Pauto had made a mention. Who had made a mention? Oh, Jonathan Silo. This is the matter. When he wanted. Okay. As prayed for, list this matter on such and such date for hearing. It's an interesting question that has arisen in your appeal.
It feels like I'm in a common law, in the English court, my lord.